This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
Okay, let's jump right into questions. First question is, I'm a board member. We have a handful of homeowners that simply ignore the violation letters or just pay the $50 fine and don't resolve the issue. What else can we do to motivate a homeowner to fix the violation? Well, I think your fine might be too low if they're just paying it. So you have to make the fine reasonable, but significant enough that it's going to motivate them to, correct the violation. I think you also may want to consider turning over the matter to your association's attorney and have the attorney send the letter to the owner and the attorney call the owner and threaten a lawsuit because, if the violation letters and the fine aren't working, you need to amp it up. And the way to do that is to increase the fine amount and or to turn it over to your attorney and or consider filing a lawsuit against the owner. Now, I don't know what the violations are. But maybe you should have a strategy discussion with your attorney to see what they recommend would be the best way to resolve this. You might also have the option to do self-help. So talk to your attorney because there are definitely remedies. You shouldn't be just having this owner continue on with the violation, paying the fine and ignoring the violation letters. There's a way to amp this up and get them to comply. Okay, next question. Our asset improvement fund. New assets, contingency fund for emergencies, and reserve fund for maintenance of existing assets all have this phrase in their resolutions. This fund shall be identified as a separate line item on the association's yearly budget and will be maintained and accounted for separately from the association's operating fund or other funds. Does this mean each fund has their own separate bank account, separate banks? It depends, really. So typically the improvement fund and the contingency fund are kept with the association's, the general fund for the association. The reserve fund is segregated typically and kept in a different bank account, typically like in a CD or something, because it's typically a large chunk of money. And sometimes it's even at a different bank because we want to stay under the FDIC limitations for FDIC insurance. So, but does this statement mean that you have to have them in a separate bank account? No, not the way that it's, worded here. It's just saying it has to be a separate line item on the budget and accounted for separately from the association's operating funds. So I'm reading this as just on the books. These funds need to be segregated, but it doesn't specifically say that you have to segregate the funds in 3 separate bank accounts. But again, my experience is that reserve funds typically are in a separate bank account. Okay, next question. An article in the Arizona Republic referred to Arizona Superior Court ruling that parts of Senate Bill 1819 be stayed. One item was a requirement that a condominium cannot be sold without approval from 100% of unit owners. Would this mean that an HOA of 39 units would have to approve of the sale of one of the units? I've had this question a couple times here in the past week or two. I do not read this particular bill the same way that you are. And so I'm not aware of this. I am aware of a requirement in the Condominium Act that talks about a change of use. And so maybe the way that this is worded is, okay, so you need 100% approval of the members in a condominium when there is a change of use. And so let's say that if there's going to be a change of use in a condominium, like a good example actually is you're allowed to have rentals in a condominium, and then the board decides we want to prohibit rentals. Well, in order to do that, that's a change of use. You'd need 100% approval of the members. So without more information on this particular issue, I can't really comment on this. but I'm not aware of, I'm dialed into this and I am not aware that this has widespread implications for associations. Okay, next question. We are a condo association. Is there any legal limitation for the dollar amount or percentage that the monthly assessment can be increased? Okay, so we talked about this a little already in my presentation. So if you're a condominium association, you first need to look at what your documents say. So what do the CC&Rs say to amend your documents? If your CC&Rs say that the board can increase the assessment rate without a vote of the membership, the board can do that. And there's no limitation in the Condominium Act that says, you know, it can be only increased up to a certain percentage, the way that the Planned Communities Act works. So there is no legal limitation other than what's in your association's documents. Okay, next question. For an amendment to the CC&Rs, do signatures need to be included as an exhibit with the CC&R amendment that's recorded with the recorder's office? So it depends, usually not, but sometimes the amendment section in the document will have a specific sentence that says that all the signatures need to be recorded. And so if it says that, then yes, of course, you would record all of them. If it doesn't say that, you just record the signatures of the president and the secretary that are notarized as part of the amendment. Question 6, my community is 4 years old. We are diverse with an Indian community that celebrates a holiday that we have with beautiful lights. Other homeowners are placing Christmas lights and Christmas decorations against guidelines alongside our special, I think it's called Diwali celebrants. Consequently, some board members are considering changing a guideline for the option for all homeowners to place Xmas lights from Diwali time till mid-January. Your thoughts on changing guidelines in the situation when a minority of the community is affected? Well, a couple things. So under the Fair Housing Act, we want to be careful that we're not discriminating against anybody because of their religious beliefs. And so I would suggest to the board that you have a little bit more flexible approach on the holiday lighting. Some people put up Halloween lights. I did this year at where I live because my kids like it and it's fun. And so, maybe you need to be a little bit more relaxed as there are different holidays throughout the year. Maybe you extend the time for the holiday lighting, maybe from, like October 1st until January 15th. And be mindful that, there are certain religious holidays that are celebrated throughout the year, and we need to be mindful not to do anything to discriminate against them because that would be a violation of the Fair Housing Act. Okay, next question, which is question 7 out of, looks like we have about 25 questions. If HOA documents are 10 plus years old, is it best that they are reviewed or amended in full or in a piecemeal fashion? And does the decision to incur this expense fall to the board, or does this require approval of the community? Okay, so if your documents are 10 years old, it really just depends. Some documents that are 10 years old don't need extensive changes, but most do, frankly. So I think if you're asking me from my experience, you probably should do a full amendment and restatement of your documents. If you haven't had them amended for 10 years, and the board makes a decision to spend the money to hire an attorney to help you with this process. It typically does not require approval of the community, and I have never seen provisions that would require an expenditure this low to receive community support via a vote, but check your documents to make sure that your board can spend this much money without community approval. I'm sure you can, but just as a caveat, do an extra check. Question 8, please speak to the fact that the board are volunteers and cannot benefit in any way as related to your position as a member of the board. Would gift baskets from a management company be considered a benefit of serving as a board member? Okay, so I already talked a little bit about during our portion on fiduciary duty and board member roles and responsibilities that the board cannot personally profit from serving on the board. And we gave examples of, maybe the association board hiring a board member to repaint the common areas or to jackhammer up the cool deck at the pool. We think that is a very bad idea, and we would advise against that. However, I am not opposed in any way from, your vendors providing thank yous to the board for their service on the board. So if your management company does a gift basket at the holidays to say thank you for working with you, I think that is fine. Now, if the gift basket contains $1,000 cash, that's obviously not fine, right? I mean, just a holiday gift basket, with a value of $50 or $100, I think is completely fine. But large gifts, which could be perceived as payoffs for keeping them on as a management company, those would not be appropriate. Question 9, should outdated CC&Rs be amended before changing bylaws? Once we're going through the process, my feeling is it's so easy just to do the CC&Rs and the bylaws at the same time. And truly, it doesn't end up costing very much more because we're dialed into changing your documents, and it's great to use the ballot to vote for the CC&R amendment and the bylaw amendment at the same time. So it's kind of like a twofer. If you're going to pick one to amend first, the CC&Rs would be first, but ideally I try to amend them both at the same time. Question 10, does the constitutional right to due process allow a member to appeal the decision of the architectural committee? No, because constitutional right is going to apply more to like public. This is private, and this is a private contract. Of course, a member can appeal a decision of the architectural committee to your board. Your board can, agree to hear the appeal or not hear the appeal, depending on what your documents say and depending on how they feel about the issue. But it's not a constitutionally protected right. Next question, 11. What do you do when the association has neglected to upgrade our bylaws, especially when new state laws have been codified by our oversight agency this past May 2020? So what do you do if your board is refusing to update your bylaws? Well, what you might want to do is show them this presentation. Go to our website after this class. It'll be posted on our Facebook Live, our Facebook page from Mulcahy Law Firm immediately after the seminar is over, and it will take a couple days to get it posted on our website. So show them our video about the importance of amending bylaws and bringing them into compliance with state laws. And hopefully they'll see the light and agree that this is something they should do once a decade. That's the best you can do. If they choose not to, you should run for the board, and put your name in the ring and get on the board and start to make positive change internally. Next question. Our HOA has not had any meetings in 24 months, including an annual meeting. They haven't shared a budget or financials and have personally selected new board members with no notice to owners. What is the best guidance? Management company and HOA will not respond to anyone who asks. Well, like I said, you can show them this video. You can scroll to this portion of the class that we're teaching here today, and you can replay it for the management company and your board. But your board has a fiduciary responsibility under Arizona law to conduct an annual meeting. If they haven't conducted one in 2020 and 2021, they are violating the law. There are many different ways for them to have an annual meeting right now. Even if they don't want to meet in person, they can do it telephonically with a conference call. They can do it via Zoom or GoToMeetings, but they have to have one. And, it might be too late to get one scheduled for December, but they should have one in January 2022. And if they aren't doing this, they are violating the law. And they need to do it, or they're going to get sued, or they're going to go to the Department of Real Estate and file a complaint against them and force them to have an annual meeting, which frankly might be something that you might need to do. Well, first show them this video clip and tell them that, hey, this is real. There's a law that says we had to have an annual meeting. Many associations, like 95% of our associations, have pivoted really well in the pandemic and are now, regularly scheduling their annual meetings via virtual means, or having them outside, or doing them telephonically. And if you don't do it, you're violating the law. And either you're going to get sued and the court's going to force you to do it, and you're going to have to pay attorney's fees for the homeowner that sues you, or you're going to go to the Department of Real Estate and an administrative law judge is going to tell you have to do it. And then you're going to have to pay a penalty, either in the form of the filing fee for the owner having to go to the Department of Real Estate, or maybe even the administrative law judge issues a penalty for your failure to do this. Next question, 13. A prior board, 7, 10, 15 years ago, an architectural committee was not active and did not object to a homeowner changing out exterior lights to a modern style, not keeping in line with our HOA Spanish Mediterranean style. Over the years, there have been several different exterior light style changes. This board is not knowledgeable as to whether they did or did not get approval. Now, a new homeowner has requested to change out their exterior lights to be similar to the modern lights of the older homeowner that was, changed many years ago. The current active board and architectural committee does not like this change to modern lights, not keeping with the existing style. From a board member's discussion with this new homeowner, we already know the homeowner will push back that another homeowner has been allowed to have similar lights. What is the best approach to address this inequity? Well, I would point the homeowner that wants the modern lights, the new homeowner, to the section in your CC&Rs that says that they have to get approval from the architectural committee before they can make an exterior change of this nature. I would let the owner know that the one that was done previously, whether it was 7, 10, 15 years ago, we don't have any records on it. And, it's too late for us to make that person change those because, there's a legal argument that we've waived our right to enforce it because so many years have passed. This board has the right to approve or disapprove, lighting fixtures, and this board does not approve of the modern light for you to do it. And just because the other owner has it from many years ago, it doesn't give you the right to have it as well. It's got to be a majority of the board. If a majority of the board feels this way, then you just need to notify that owner of that. And I think you're on a really strong ground legally. It's only one owner that has the modern lights. And this is a common problem that we see in associations. It could be lighting, it could be, RV gate. It could, sometimes violations happen and time period is too long for us to go back and try to to correct it. And it's only one owner. It's not like 67% of the owners have these modern lights, which would make it a different situation, frankly. If that many owners had it, it could be a substantial disregard of, the old world lighting that, is what the board wants to have to keep the Spanish architecture, and nature of the community. So I hope that answers your question. Next question, question 14. Regarding fines, who determines if a fine is reasonable? Our process is a courtesy letter, a second notice giving them 14 days to correct the issue, outlining possible fines, offering the homeowner an opportunity to appeal. Our fine schedule is an initial 25 and 10 per day until the problem is fixed. So that does seem, reasonable. The max out on that would be like $310, a month if they don't, correct it. I mean, I think here's what I would say. So we have to, who determines if the fine's reasonable? Ultimately, the board makes the decision. If the board is challenged on it, a judge will make the decision. So it could be in Superior Court, it could be administrative law judge in the Department of Real Estate. So what I would look for on a fine is, I've been doing this type of law for 25 years. So I can tell you a couple examples. So if, somebody's got an RV parked in the association and the association is only fining them $40 a day and the homeowner just keeps it there because it costs $55 a day to store it at RV World, and then the board wants to raise it to $75 a day because it's going to be, more likely that the owner is not going to store it there anymore and will pay the storage fee at RV World, that's going to be fine. But here's another example where, like, let's say I had a case many years ago where the association had fined an owner something like $8,000 for not trimming their palm trees. And really, to trim the palm tree, it would have only been about $125. That kind of doesn't make sense. That's too high. It's not working if you fine somebody $8,000 and they're not, correcting the violation. You may want to look at self-help or something like that. But so I think a court's less likely to award, a really high fine amount if, the issue and dispute is, not that big of a deal, like leaving trash cans out or something like that. Like $1,000 fine for that's going to be considered unreasonable. So I hate to say it this way, but you know it when you see it. So if you want to run your fine policy by me, I'd be happy to give you my opinion. The one that you put here, $25 initial fine and $10 per day until the problem's fixed, seems reasonable to me. Next question, 15. Are HOA insurance claims open for residents to review? That's kind of a good question. Probably yes, but I mean, it depends on what you want to review. I mean, if you want to go to the insurance company and review their file, they're not going to give it to you. But the association, if you request it, should be willing to give it to you. I can't imagine that there'd be any personal information in there regarding a homeowner that would be a problem. But these are, just all things that, you can request. I wouldn't have any problem advising a board to give, typically you have the insurance company come out, an inspector comes out, gives a report. If somebody wants to see that, I think you should give it to them. Now, if there's like a legal part to this where the lawyer for the association is writing an opinion to the association about a claim, then that would not be discoverable. So I guess it just depends on what you want to see. Question 16, we have a homeowner wanting to have a contractor to put in a gas line. We own the street and the area up to our walls. A new street and watering system are in. We do not want the contractor to rip up our new street, damage the sewer and water lines. We require a change letter to be submitted to the board for a vote. Scottsdale City also needs a permit for this. Can we require an escrow account to be created by the owner or the contractor? I mean, I suppose you could. They'd have to agree to put the money in there because the CC&Rs, don't have anything that would, force the owner or the contractor to do this. I think what you want to do is that when you give approval, you need to say you need to return it to like condition as it was when you started the work. And if you cause any damage, you're responsible. You could maybe require like a bond, like a construction bond or something like that. And I'm sure that the contractor already has one with the Register of Contractors. You want to check to see if the contractor is in good standing with the Register of Contractors and that their bond and insurance is active. But, can you force this? If it's in your CC&Rs, yes. But if it's not, it's going to have to be voluntary compliance by the owner and the contractor. And of course, if they screw up and they don't do what they're supposed to do, then you have legal claims against them. Next question. With insurance, is a fidelity bond required by law? If someone on the board has a felony charge and cannot be bondable, does that mean they're ineligible to serve on the board? Is the fidelity bond on the association or on individual board members or officers? Okay, great. I heard already from my office that we've already provided you with a cheat sheet on insurance, so take a look at that. So no, a fidelity bond is not required under Arizona law for condominiums and planned communities. It may be required under your CC&Rs. So check your CC&Rs to see if that's something that you're required to have. If someone on the board has a felony charge and cannot be bondable. Okay, so I've never heard that before. You probably want to check with your insurance agent. I'm assuming that they're the ones that are telling you that. Does that mean they're ineligible to serve on the board? Not necessarily. I would want to find out more information about the felony, and that also may need to be disclosed on the Corporation Commission report, annual disclosure about board members, just as a side note. Is the fidelity bond on the association or on individual board members or officers? It just depends on how it's worded. Typically, it covers any claims that are made regarding misappropriation of funds. It could include board members, it could include officers, it could include the management team, it could include anyone else who may have access to the money for your association. So you have to read the specific language of the fidelity bond, but it's going to cover people who have access to the money, and it protects the association, whereas the association is going to get paid out if somebody steals money from your association. You want to make sure on the fidelity bond that you have enough. Most times we see like 50 grand. You want to look at how much money you have in your accounts at any one time, to think about what amount do you want to have as a fidelity bond. I would keep like I said earlier today, keep your reserve account segregated and make it difficult to get that money out of there. So you need to have a majority of the board sign something to transfer that money. That money should not be able to be transferred online ever. That should be very difficult for somebody to get that money out. So you want to look at how much you have in your checking account, throughout the month. That may be enough to have as your fidelity bond amount, or you may want to also get an additional fidelity bond to cover how much you have in your reserve account. I know I'm aware of one association that had a claim for a manager stealing money over $500,000 from the association's funds. And the association had $1 million fidelity bond, and thank goodness, because that really saved the association. We were able to get back, a very large portion of the money that had been taken because we had such a high fidelity bond. Okay, next question is question 18 out of, looks like we're up to 27 questions. So what are some strategies for getting owner participation in the CC&R vote? 75% is high. Most of our owners aren't active with the HOA votes. Some strategies would be do the vote in conjunction with your annual meeting. Maybe put something controversial as a sidebar on your vote that people are really going to want to vote against. I hate to say it that way, but maybe something that's really controversial that people will get fired up to vote on. You could do that as a side vote for the entire CC&R vote, just to get people to participate. Usually what we find is we get about 45 to 50% who respond with just the first request to respond, the first letter. And then really from 50 to 75%, it is just blood, sweat, and tears. You have to send multiple letters out. You have to do phone calls. You have to email the people. You have to show up at their front door with the ballot. It's very difficult to get that next 25%. So that's very normal. But just continuing to contact them and let them know, hey, we're going to keep contacting you until you vote. We don't care if it's yes or no. We just need you to vote. Next question, 19. Can owners attend announced committee meetings and ask questions and make comments? Are they only allowed to listen? So if it's an announced, I'm assuming that you mean it's like properly noticed. And so remember that committee meetings that are regularly scheduled are treated just like regular board meetings, meaning that you have to give notice of the committee meeting, and owners should be allowed to attend, listen, and participate. So without knowing more about what announced means for your community, it's hard for me to comment on this, but if your association is having regularly scheduled committee meetings and the association is complying with the open meeting law for the committee meetings and providing 48 hours notice, owners are allowed to listen in, and they're allowed to make comments before the committee takes formal action on something. Now, if it's not a regularly scheduled committee meeting, then they're not subject to the open meeting law, and it's at the committee's discretion whether or not they can allow you to participate and listen. But if we have committee members listening in here on this call, be respectful and welcome input from your homeowners, even if it isn't a formal, noticed, regularly scheduled committee meeting, because remember, we are serving our communities and we want to make sure that we're listening to everybody's input as homeowners. Question 20, our master association documents are not correct in regard to the Arizona statute for flagpole height. One of our sub-association homeowners, an attorney, pointed out the current Arizona statute takes precedence over HOA rules and regulations regarding flagpole height. Our HOA attorney confirmed the sub-association homeowner is correct. I advised the master association community manager, but the master rules docs remain incorrect with regard to the Arizona state statute. Master Association doesn't seem concerned about having incorrect design rules. Should we adopt correct rules in the sub-association docs so our sub-owners have the correct guidance? So yes, I would, adopt what's consistent with Arizona law would be my suggestion. And, maybe the Master Association recognizes that their documents are incorrect and they are following what state law says. I hope that's what the case is. And the next time that they do an amendment, they'll sweep it in and correct it. If you want to amend your documents and a part of it affects only one part of the community, do you need to get 100% approval of those residents affected? Maybe. So the Planned Communities Act says a provision like that talks about, like an example would be, let's say you want to pass an amendment that anybody who has wrought iron fences on their property within the association must pay themselves to repair and replace it. And not everybody has wrought iron fences. In that case, if it's a planned community, you would have to get 100% approval of the wrought iron fence owners. But every issue is different, so I hate to just give you a blanket. If it affects only one part of the community, I'd have to hear more about what it is in order to give you my specific opinion. Question 22, can the HOA board force vaccine proof to attend a meeting when Zoom is so easy to use? Our owners prefer Zoom, but one board leader is demanding on-site with vaccine card review. Okay, I would agree. Most of our clients are now conducting Zoom meetings only. Truly, I very rarely now go to a meeting in person. Most of our boards are meeting via Zoom or conference call, or if they are meeting in person, they're doing it outside, and then they have their vendors Zoom in to save on costs, travel costs. Is it unreasonable for a board to force vaccination proof? Probably. I do think that is something that might be deemed unreasonable. We're advising our clients that you shouldn't get involved in the whole vaccine wars. It's just not something that we are suggesting based upon how politically charged the issue is. And, everybody has a different opinion on it. I suppose maybe a pivot here would be, maybe you could, if you're not vaccinated and you want to go to the in-person board meeting, maybe you can wear a mask, and that should satisfy the board. Next question, 23, an owner made exterior changes prior to board approval. Board voted it would not have approved the changes if they had asked for permission beforehand. Should homeowner notification to restore changes be sent by the attorney? Possibly the management company or the attorney. And I think you kind of want to look at, what did the homeowner do? Is there any modification that they could make that would be something that would be a win-win, that we could fix this with and have them submit, a modification, or do you want it just to go back to what it was? I think you should talk with your attorney about it, but the response letter can come from the attorney. And I think you should strategize with the attorney as to, okay, what's the best way to handle this really unfortunate and difficult situation? Next question, if 50% of the board get together for a walkthrough, is a meeting notice needed? It depends. What is a quorum? So usually a quorum is, like if you have a 5-member board, a quorum is going to be 3. And I don't know what 50%, I guess if you can't have a half a person, right? So I'm not sure where you're going on that, but anytime a quorum of the board is present discussing association business, it's considered an open meeting and you'd have to notice it. Our HOA replaced unit gates 3.5 years ago. Mine did not need to be replaced then, but it does now. They're refusing to replace it at this time. The majority have been replaced. Shouldn't all or none have been replaced at one time? Isn't this a matter of discrimination or favoritism? All the board members have new gates. Okay, well, here's what I would do. I do think that I don't know the facts regarding the gates, and why they were replaced. Was it part of an insurance claim? Was it something the board just did, even though they weren't required to do it? I would really need to know more information before I could give a good opinion on this. I'd also want to hear why they're refusing to replace it. I guess my thoughts are, listen to what they have to say. If the association is required to replace the gates and yours needs to be replaced, you have a strong legal argument to have them pay for it. Does the board have to replace things, all at once, even if something doesn't have to be fixed? No, they don't have to do that. But you have to look at what the maintenance responsibilities are under your documents, and they have to follow those. I don't know if it's a matter of discrimination or favoritism because I don't know what the board's position is on this. Okay, next question. Is a reduction of monthly dues for the board president considered self-dealing and profit from serving on the board? That definitely is something that I'm not in favor of. I'd have to hear more about why this is occurring. There is a section, just in the Nonprofit Corporation Act that allows a board member to be compensated, for providing work to the association or maybe even for serving on the board, but it has to be listed in your bylaws that it's allowed. Although I'm going to tell you, as legal counsel for associations, we strongly advise against that. So is it unusual? Is it self-dealing to have a board member have a reduction of dues? I think it is something that needs to be investigated, and it's not something I would ever be in favor of. Our rules and regulations require property owners to submit their contact information, their contact info, residents of the property, and license plate to the board and management company. I'm guessing this is for like a rental. About half of the homes have either refused to submit it or just ignore it. What are our options? Okay, so under the statute for rental properties, you can ask for this information and they have 10 days to provide it to you. You can charge them, I think it's a $25 fee for each new rental. And then if they fail to provide you with this information, you can add on a $15 fee, I think it is, if they don't pay it. So again, these are small dollars, right? You can sue them if they don't do it. I'm not sure it's going to be worth it for you to do that. You can turn it over to the attorney to send them a letter. But the amount you can penalize them for is going to be limited to the $25 per new tenancy plus $15 for not providing it. Last two questions. Is there a rule of thumb what dollar reserves we should have to cover damages to our units that are not covered by insurance? So for example, like deductible. Gosh, it's hard to know. I don't know if you're a condominium. I'm assuming you are. How many claims you have, how old your association is. So it's really tough to say. A good rule of thumb would be go back and look at the last 5 years and see what type of claims you've paid out, and what your current maintenance, and what your current age of your community is. And you might want to allocate dollars after looking at what the trend is on your year-to-date budget for the past 5 years. And the last question is, we are a planned community. The town owns our streets. Our community was developed in 1979 under Maricopa County. They transferred it to the town in 1984. The town signed off on drains and plans when they took over. This year, a drain overflowed, caused damage to a homeowner, and the town claims that the drain is the responsibility of the HOA. There are no records of HOA having knowledge of a drain since the town owns the streets. What should the board do? I think what I would do is I would go back and look at the plat for your association. This is not something I can answer on this platform because I'd have to do a little research, but our firm would be happy if you hired us to look into it further. I would look at the plat. I would go back to the county records. I would look at the town records and determine what they have that indicates that the association is responsible for this. I don't know where the drain is located, so that's also something that would be really important to investigate further. Thank you so much for joining us here today for our 11th class of the 2021 Virtual HOA Academy. I'd like to take this time to thank the neighborhood services departments from Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for their teamwork and continued partnership with Mulcahy Law Firm to put together these amazing virtual classes. Be sure to join us for our last class in the series on Friday, December 3rd. So we're having a little date change up. It won't be on a Tuesday in December. We're going to do it a little early so we get ahead of the holidays. So our last neighborhood services presentation is going to be Friday, December 3rd, 2021. We're going to be doing it in conjunction with our firm's free call-in. So we're going to have a free Q&A session for board members, managers, and owners on HOA and condo law. And we're going to call it Bring Your Questions, Big and Small. The class doesn't end until we answer them all. So bring all your questions, bring as many as you have. There'll be no limitation on the number of questions that you bring. To submit your questions and to get more information on the start time, go to our website at mulcahylawfirm.com, click on our seminars tab, and you'll be able to sign up, get the Zoom link, and also submit questions all at once. And be sure to join us on December 3rd because it's going to be a great holiday class and we're going to answer all your questions for free. So thanks everybody for being with us here today. Happy Thanksgiving to all of you, our friends, our clients, our participants who've been listening into our virtual seminars over the past year and a half. We hope you have a wonderful holiday that's safe with your family, and we wish you all the best. Take care, everybody. Have a great rest of the week.